Welcome to the 2021 Current Issues Workers' Compensation Conference, brought to you by the law offices of Richard L. Montalbo and sponsored by Apple. Innovation for your world. LexisNexis, not just more content, but more efficient research tools. Gemini copying and subpoenaing services, assisting both the defense and applicant bar. Arcadia and John Pinto, your structure financial settlement professional. MacroPro copying and subpoenaing services, MedLegal legal services, ExamWorks, provider of workers' compensation evaluations, and MedLink, professional medical legal evaluators, and Amitros savings and support for injured workers. This year's conference was again virtual, but webcasted from the historic and elegant Vizcaya in downtown Sacramento on March 19, 2021. Before we begin, you may wish to download the conference materials which are available without charge at montalbolaw.com. Should you be interested in CEB, MCLE or QME credit, please contact the law offices of Richard L. Montalbo for terms and to receive your certification of completion. The opinions expressed herein are the opinions, legal interpretation and analysis of the presenters. The viewer of this video presentation is encouraged to review in its entirety the case decision or statute which is being discussed. The 2021 Current Issues Workers' Compensation Conference involved 4 separate panels and sessions of just over 1 hour and 30 minutes each, and qualifies for 5 hours of CEB, MCLE or QME educational credits. The first session will be Case Law Update, Part 1, with the focus on case decision originating with the WCAB. The areas of emphasis for this year's conference will include apportionment, permanent disability, litigation involving COVID, and jurisdiction. The panelists include Mr. William Herreras and retired Judge Dudley Phoenix. The moderator for this session will be Mr. Richard Montalbo. Mr. William Herreras is a graduate of Loyola University of Los Angeles. Mr. Herreras is a past president of California Applicants Attorneys Association and has been co-chair of the Amicus Committee for CAAA since 1982. Mr. Herreras is an active member and lecturer of the Mexican American Bar Association and various other legal conferences and symposiums throughout the state of California. Joining Mr. Herreras is retired Judge Mr. Dudley Phoenix. Mr. Phoenix is a graduate of UC Davis Law School. Mr. Phoenix was recognized in 2006 as one of Sacramento's best lawyers by Sacramento Magazine. Mr. Phoenix was a workers' compensation judge with the Sacramento WCAB for over 2 decades. He is currently a partner with the firm of Timmons, Owens, Jansen and Tishy, a practice which focuses on representing police officers and firefighters. Rounding out this panel as moderator is Mr. Richard Montalbo. Mr. Montalbo holds degrees in business economics and computer science and received his law degree from the University of the Pacific McGeorge School of Law, where he is currently an adjunct professor. He is also the architect behind Current Issues Workers' Compensation Conferences and a frequent presenter at various legal conferences and symposiums throughout the state of California. In addition, Mr. Montalbo is developer and designer of the CompCalc app, the only smart device workers' compensation rating and indemnity app, as well as the author and editor of the Work Comp Index, a topical guide to the law of California workers' compensation. Let's join our panel already in session.
Let me start by inviting or welcoming everybody to the 26th Annual Current Issues Workers' Compensation Conference. My name is Richard Montalbo, and I'll be the moderator throughout today's proceedings. Once again, we've been fortunate enough to have some of the top legal minds in the field of workers' compensation participate. Before I get into that, I want to go ahead and review what happened last year with our conference. You know, we were probably the first conference to go virtual, and the way that came about was the governor assisted us in that. We started out planning to have a conference with about 250 attendees. He reduced that to 150. It went down to 50. We were fortunate enough with Sean of Sacramento Video to put together at the last minute, and we tested 3 different platforms. We tested Facebook Live, Zoom, and Skype, and we decided to go with Zoom. And it went pretty well, I thought, last year. But what I couldn't anticipate was the following, and this goes to the additional question that I've had leading up to today's presentation. That is, why, Richard, are you essentially giving away 5 MCLE specialization and QME credits for no charge? And that's because of what happened last year. And I just have to give a tip of my cap to everybody that has attended this conference over the last 26 years now. We had, the turnout wasn't as good because of COVID and everything leading up to it, but you have to understand that that was at the initial part of the lockdown. So the costs were incurred and the contracts entered into. There was some modification, and right now I'm coming from the Vizcaya, and they did make some reasonable concessions, but by and large, all those costs were locked into. Now, what I expected was that there would be a number of people that would ask for a refund, and that's what I found so heartening. We had no request for refunds. And although I had to underwrite it and there was a substantial outlay on my part because of the COVID situation, because I had obligations ahead of time, nobody asked for their money back. So my point is, it could have been a lot worse. That led to my decision this year to go ahead and provide MCLE and specialization and QME certification without charge. So that's kind of I think we all, through the past year, I think we're all happy to have last year concluded. Let's go through right now. Hang on. Let me go through how the MCLE and specialization credits are going to be handled. You'll note that there are 5 units, although there's only 3 hours of live presentation. Those 5 units represent 3 hours of live presentation and 2 hours of self-study. At the conclusion, everybody who's enrolled will receive a copy of their certificate, along with, if they want QME or MCLE certification, along with a declaration. This is a State of California State Bar form that requires the participant to get all 5 hours, including 2 hours of self-study, to sign this declaration and return it to our office. Essentially, it says that you've completed the additional period of self-study. What is the self-study? Well, I've provided you with a fairly substantial amount of information by way of materials. The first half of the materials are the 2020 and 2021 case law update. Excuse me. Today's presentation is going to focus on the 2021 case law update. But I've also provided you with all the, what I would say, the rough draft or the raw materials for my book, the Work Comp Index, a Topical Guide. And these entries, which are another 20 pages, are the entries intended to go into my book. Some of them are in the 2021 version that's out now. The ones that you'll see at the latter part of the handout are from March of last year until September, which is the deadline for my book. And then you'll see additional entries over the last 6-7 months. What I would suggest, and I think this is just a good way to study and get up to speed, if you just take the time to quickly read those entries, and then if there's something that you want further, you'll see that there's companion sites, cross sites, and read the actual case, which is also given in each one of those. And that's how you'll make up the additional 2 hours. So the additional 2 hours would be a combination of reviewing 2020 case law update, along with the materials provided for the Work Comp Index, those rough draft materials. Within a week, you'll receive both these documents. Be sure, if you want MCLE and you want QME certification, that you return that declaration to my office. That's a requirement. If you're here and you're listening to me, you've already made it to my website. You've probably saw that there was a button there for downloading the materials in a PDF. A couple of items about that PDF. You'll see that there's a table of content, and you'll see that that table of content is live. So if you move your cursor over it, you'll be able to flip back and forth between the cases to make navigating that document a little easier. Last, persons that attend this conference will be provided with a download, a free download today. And I know this will probably go viral and everybody will be aware of this, of the CompCalc. And I entered into an agreement. Well, for those of you who don't know anything about the CompCalc, it's the only fully rating and indemnity program with a number of modules for your iPhone, your iPad, your Droid devices. It's also available at the Microsoft Store, at the App Store for your Mac computers, and then also we have an AWS version for the internet. Last year, CAW adopted the CompCalc for their paid membership. It's on their website, and currently it's in testing with AIG for adoption. The iOS, which is your iPhone version, and the Droid version for your Droid devices are available for download. And this is, if you have a Droid or if you have a iPhone, you go to the App Store, the Google Play, tap on the search feature, put in my name, and the one that you want to download is the orange Gemini Calc, because Gemini and I entered into a license agreement 2 years ago for distribution of that. So that's available as well. The only additional information that I would provide about the CompCalc, once it's on your iPhone, you don't have to have connectivity to the internet. Once the program's downloaded, you can go ahead and do perform all the calculations without a 5G connection, except for the training and support module. That module, you'll go up to the internet and you'll see there's basic features and functions, advanced tips and techniques, and rating with the CompCalc. And there's 3 8 to 10 minute videos, you'll have to listen to me speak, describing all the features and walking you through the CompCalc. And that'll bring you up to speed. Okay, we're going to have 2 separate sessions today, each an hour and a half. And we'll have a 15-minute break in between. So we should be taking a 15-minute break sometime around 10:30. Let me go ahead and introduce our speakers. You know, every time I put on this conference, and this year's an odd conference, usually I have between 6 and 8 speakers, and we have multiple topics, and it's a full-day event, you know, with great food and specialty coffees, and it's concluded with a raffle and a wine tasting. And it's kind of a, for a conference, I like to think it's kind of an upscale conference, and it's been fun for me. This year, I will tell you, as I look around here, there's a few invited people and staff and our media people. This is kind of a sad conference. Because it's just not what it has been in years past. And both of the speakers that are joining me today have spoken previously, and they know what I put on. I kind of throw a party is what I do, only we all come here to study workers' compensation. I guess that makes us all a little too wonky, perhaps. But joining me today are retired Judge Dudley Phoenix, along with William Herreras. You can read their bios, and what I thought I'd do by way of introduction is give you some thoughts about both. And neither one knows what I'm about to say, but I'm going to start with Judge Phoenix, who's now with Timmons, Owen, Jancy, and Tishy. This is what Judge Dudley does not know what I'm about to say. But over the years, I don't know how many years he was on the bench, 15, 20, something like that. I would sit in his courtroom with some frequency. And he may not know this, but this is the truth. I was sitting in there for 2 reasons. Number one, to listen, because there was always an issue that I wanted to hear his take on it. Secondly, and this is important, judges have 2 critical components to their job, and some judges do it better than others. And those, from my vantage, those 2 components are knowledge and experience, knowledge of the law and experience. And most judges knock that out of the ballpark. They're all knowledgeable and they're very experienced. But the second component that I think is so critical is judicial temperament. And perhaps I flatter myself, but if I was ever a judge, I would hope that I would have the judicial temperament of Judge Phoenix. You walk into his courtroom, he was always a good guy. didn't mean that people didn't respect him and he didn't have control of his courtroom. But his demeanor, I always felt, was just second to none. And it was, so I tip my cap to you, Your Honor. It was always a pleasure appearing before you. Second, we have William Herreras. I don't know what I can say that hasn't already been said other than a story as well. And I told Bill that I was going to tell this story. About 5 years ago, Bill and I spoke for the state bar. And we were speaking on Ogilvie. And there was a question from the audience. And I'm sure I mumbled through something that probably wasn't complete. And Mr. Herreras took the floor to fill in the gaps. And he spent the next 15 minutes citing cases and discussing historically how we got to where we are. And at the conclusion of that, this is no kidding, at the conclusion of that, I realized that I was staring at Mr. Herreras with my mouth open. And instinctively, I realized people were probably looking at me. And so what did I do? Without missing a beat, I was going to save myself. I pointed at Mr. Herreras and I said, him, I want to be him. And that's a true story. It happened. The audience laughed. And, I had the pleasure, this is on a side note, I had the pleasure of taking constitutional law a full year from Judge Anthony Kennedy, U.S. Supreme Court retired. And Judge Kennedy had the same ability because he had so much knowledge, so much experience, had watched the cases come up through the trial court and the Court of Appeal. At the time, he was the Ninth Circuit Court of Appeal, that he could do the same thing. And he would come in and provide us with so much background information. And hopefully today we're gonna see some of that. I think that we are. At the conclusion, before we begin, at the conclusion, I haven't touched on this, we're still gonna have a great raffle. We're giving away about $5,000 in Apple gifts. Of course, Apple is a sponsor. Apple gifts or Apple items, as well as some great bottles of wine. We might not be able to have a wine tasting, but we're going to, as I look out here, some people are smiling. We're not going to have a wine tasting, so don't think that out there that I'm bringing in wine for everybody. I haven't, but we're going to raffle off some great bottles of wine, and I'm really excited to do that. Okay, let's go ahead and get started. The first case I'm going to take, and I didn't think it was going to be too controversial, but I'm going to tell you, in speaking with both of my counterparts just before we went live, it's going to be controversial, much more so. But before we get to it, what I'd like to do is give you an overview of how I think about the law of apportionment. Whenever I'm reconciling cases, and I think attorneys often misinterpret what the holding of a particular case is because they don't think about these three doctrines. And this is how I teach it. The three doctrines are the doctrine of substantial evidence. A lot of these cases stand for nothing more than a party didn't meet their burden of proof on the issue of substantial evidence. Second, a lot of these cases stand for the proposition that the party that had the burden of proof didn't meet that burden of proof. And last, when it comes to apportionment and PD, direct causation, the doctrine of direct causation. Let me go through each of these simply. Substantial evidence requires that there must be evidence to support the opinion or the conclusion reached, whether it's by F&A or by medical opinion. In workers' compensation, generally we have two different types, primarily two types of evidence, and that's going to be factual evidence and medical evidence. Whether it be the WCJ by way of F&A or the physician, they have to use those facts to support their ultimate opinion. In some cases, the opinions just don't constitute substantial evidence, and the opinions don't mean anything more than that. They're not articulating a rule of law, they just didn't meet it. Next, we have burden of proof. And simply stated, and this is how simplistic the burden of proof is, it's complicated when it's applied, but the burden of proof is generally, you have to know two things. What is the standard and who has it? The standard in workers' compensation is going to be what? Preponderance of the evidence, greater than 50%, more likely than not. Who has it? This is the best rule, the best way that I can articulate who has the burden of proof. It's always on the party that at that point in time will benefit from the affirmative of the issue. So who has, let me give you some examples, who has the burden of proof on injury AOE COE? Well, initially it's always with the applicant. They have to establish what? An injurious event, activity, or exposure resulting in permanent disability. That's the requirement within the course and scope of employment. They have to establish that. Then the burden can shift. What about apportionment? And this is important. This goes back to the old Pullman-Kellogg case that I'm sure Bill was involved in. But Pullman-Kellogg stands for the proposition that it's the defendant who has the burden of proof in coming forward on the issue of apportionment. Direct causation. Now, a lot of the cases that we're going to discuss today, especially the PD and the apportionment cases, I think can be explained, and this is how I organize it in my book, under the doctrine of direct causation. Direct causation, simply stated, says that the employer is only liable for that portion of, and I say it this way, whole person impairment and/or resulting disability, although I know we only apportion the disability, okay? But the disability, which is directly causally, and I say exclusively, related to the subject industrial injury. And this is where you get into asymptomatic pathology, pre-existing non-industrial causation, and that generally is apportioned out. And I think that's what 4663 and 4664 provide. Let me go through with you now the law of apportionment. I always suggest that people who understand the law of apportionment have to check the box on 4 different issues. First, we've already gone, who has the burden of proof? That's Pullman-Kellogg, it's always the defendant. Second, you have to understand the difference between apportionment of liability as between co-defendants and apportionment, strict legal apportionment of PD. Apportionment of liability as between co-defendants applies to all species of benefits. Strict legal apportionment is causation of disability. It only applies to disability. And here, I want to make sure that everybody understands, and this is complicated, it's often confused, the difference between causation of injury and causation of disability. Causation of injury, and this is how I explain it, is a threshold issue. Do we have an industrial injury? The standard for that under South Coast framing is just a mere contribution, something greater than 0. Once you have that, you have an industrial injury. That requires that you have an injurious event, activity, or exposure, and injurious industrial event, activity, or exposure that results in PD. Where you have that, you're going to have an industrial injury, provided there's just a mere contribution. And a lot of people misinterpret, I believe, the holding in South Coast framing. A lot of defense attorneys say, well, that's a death case. And of course, you can't apportion death benefits. But they miss the holding. The holding is a holding on causation of injury. What they held there was that there was a mere contribution, something greater than 0, that resulted in this industrial injury. And they're right that you don't apportion death benefits, but in establishing causation of injury, you're now able to, in a case not involving death benefits, reach the causation of disability. Causation of disability, the next point, you have to know that there are only 2 sections in the Labor Code that allow apportionment of disability, causation of disability. And those are Labor Code Section 4663 and 4664. I'm going to start with the section that I say is a throwaway, because it's difficult for the defendant to do this. And I know Judge Phoenix was involved in the Coping case, and feel free, gentlemen, to jump in on this. But let's start with 4664. The reason I say that this is a throwaway case is because 4663 is easier to establish, the elements are easier for the defendant, and even if you can't meet the requirements under 4664, you can always go to 4663 to establish apportionment. So what are the elements for 4664 apportionment? There are 3. Number 1, you have to establish a prior award. Under the Pescato case, that's not a compromise and release. A prior award is either an F&A or a stipulation with request for award. Number 2, I say that it's very difficult for a defendant to establish apportionment under 4664 to a prior award where they're not on the same side of the fence. And now that has 2 aspects. What do I mean by the same side of the fence? It means that you have to be dealing with successive injuries that either involve the old guidelines or the AMA guides. And there's one other aspect of that. I believe it makes it very difficult to establish apportionment under 4664 where you're not using the same methodology, even where you're using the AMA guides, okay? And to establish overlap, you're going to have to establish the same region or part of body, same methodology, same side of the fence. And then last is overlap. You have to establish that that prior award, in part or in total, well, that's why you want to be in 4664, that it overlaps the prior award, or the prior award overlaps the current level of disability for the purpose of taking apportionment of that prior award. I'm just going to ask a question of Judge Phoenix. What are your thoughts on establishing overlap? Is that a medical issue? Is it a medical legal issue? Or is it a legal issue? In other words, is it left with the doctor? Is it left with the medical legal evaluator or the judge? Or is it a combination? How does that work?
Well, I guess an easy example of that would be the Coppin case. And as you mentioned, I argued that way back when before the Court of Appeal. And in Coppin, the case involved subjective factors of disability, and the applicant had a prior award based on work restrictions. And so exactly as you just said, the question first was medical, right? Because the question is, what was the prior disability versus the current disability? And then once that was established, the issue became legal. So I would say, Richard, it's probably both. First medical, addressed by the QMEs or the AMEs, and then when we get before a judge, it becomes legal, and the judge has to make the determination as to whether the factors of disability in fact overlap, just as you just said.
And that's going to, once again, that's going to turn on substantial evidence. The judge is going to look at whether or not the opinion constitutes, the medical opinion constitutes substantial evidence on the issue of overlap.
That's exactly right.
Okay, I want to touch now on the second way in which we establish apportionment, and that's going to be causation of disability under 4663. What I say here is there are three elements to this. Number one, the opinion, and they all turn on substantial evidence, whether or not the opinion constitutes substantial evidence. Whenever I read a medical report, this is my checklist to see whether or not that opinion on apportionment constitutes substantial evidence. Number one, that opinion has to be based upon a full, complete, and accurate medical history. A full, complete, accurate medical history with a proper diagnosis. If you don't have any of those components, and we have cases, what I'm doing with these three elements is I'm taking a number of cases that have decided individual issues and put them together to help the listener understand what I think the checklist should be. So a full, complete, accurate medical history with a proper diagnosis. Number one. Number two, the opinion has to be expressed in terms of a reasonable medical probability, not certainty, not possibly, but reasonable medical probability based on the doctor's education and training and experience. So reasonable medical probability based on the physician's education, training, and experience. That means essentially that the doctor, if he's a chiropractor, can't comment on psychiatric disability. A internist, a doctor of internal medicine, is probably outside of his scope if he's commenting on orthopedic injuries, okay? And then last, the doctor has to provide the how and why. He has to tell us what it is that causes him to believe that there is apportionment either to non-industrial causation, subsequent or prior industrial causation, or subsequent industrial causation. And he has to put that out in terms of reasonable medical probability. And the cases tell us he has to connect the dot. He has to provide us with considered and reasoned analysis. He has to explain to us the how and why. That's what the cases tell us. Okay, so with that as a backdrop for apportionment, let's start with the first case. The first case, this California Department of Corrections, is going to be a heated argument. Mr. Herrera does not like this, and it appears that Judge Phoenix is at odds with this too. I'm not sure that I am. What happened here? Here's the issue. Where you have a total award of disability, where there's no question that the applicant is 100% disabled, are you entitled to apportionment? That's what this case asks, and arguably by way of a panel decision answers. And we have a number of cases, panel decisions, that are on both sides of this issue, just so you know. I happen to like this because I'm a defense attorney, and I've, over the years, suggested that this is the way the ruling might go. In this case, we have 3 dates of injury. We just have a 2005 that's an orthopedic, right hand, neck, back, and knees. We have a 2006 date of injury that includes knees, but also internal problems, including eyes, diabetes, cardiovascular hypertension, psyche. We have 2 AMEs. We have an internal medicine doctor and we have an ophthalmologist. The internal man, the applicant is legally blind. That's the issue. If he's legally blind, then he's 100% disabled. There is, and this is where the argument's going to ensue, there's a conclusive presumption under 4662 that a person that's legally blind is conclusively presumed to be 100% disabled. But what happened here is the internal AME said that he would apportion under Benson 30% to the 2006, 30% to the 2012, and 40% to non-industrial causation related to the diabetic condition. The ophthalmologist confirmed that the applicant was totally disabled due to blindness, but then he deferred to the AME on the issue of apportionment. The WCJ was left with the dilemma of whether or not to apply the apportionment or make a 100% award. I want to read to you what the WCAB held on this. By split panel decision, the WCAB held that the conclusive presumption of 4662 does not preclude apportionment to causation of disability. Writing, the board held that 4662 states that although the permanent disability shall be conclusively presumed to be total in character, the statute does not mean that it is conclusively presumed to be 100% the result of the industrial causes. Looking to the legislative intent, the majority noted also that 4662A does not specifically exclude apportionment to Labor Code Section 4663, which the legislator could have done if they had intended it. Now, it's probably obvious why I like this as a defense attorney, but I'm going to take the first whack at why I think that this is correct. And I'm going to do this by an analogy. First of all, let's talk about the public policy behind 4662 and the law of apportionment. The public policy is that we want to encourage employers to hire disabled workers. And if we want to encourage that, do we want the employers to be saddled with 100% disability, where otherwise their injurious industrial injury caused 10% or 50% or 75% even? I think that that would discourage an employer, and perhaps they're not that sophisticated, but would have some impact on discouraging employers from hiring disabled workers. So what we want to do is we want to apply the doctrine of direct causation and state that the employer is only liable for that portion of the disability which is directly and causally related. Now, I explain this decision and my position because you go back to 2000, I think it was 2003, might have been 2002, the Sanchez case came down, and it held otherwise. It held that there was no apportionment because of the conclusive presumption under 4662, but there was a dissenting opinion that I found very persuasive and really formulated my opinion on this issue. This is under the old 4750 statute, but it was authored by Jim Cuneo, who was on the board at that juncture. And he made what I thought was a persuasive argument. From that, I gleaned the following analogy, and I want to walk everybody through this. The first misnomer is that people can only be 100% disabled. No, people can have disability greater than 100%, but they are only entitled to an award equal to, but not greater than 100%. Now, how does this arise? This is where somebody comes to the workplace, is able to work, and has bilateral injuries to hand where they can't use the hand. So they're presumed to be 100%. Now, that's not causative of the work. There's no industrial injury, but they have 100% disabled by statute, but they're able to work. So the employment, the job is congenial to that level of disability. And then they have a subsequent industrial injury. Can the defendant come forward? And I'll throw this out to Mr. Herreras to take this argument. Can the defendant come forward and say, hold it, they already are 100% disabled They can't be more than 100% disabled. I don't have to pay you for the injury to the knee. Bill, what are your thoughts on that?
Well, I think you have to get back to the policy behind a person's ability to work in the labor market. There are people who are 100%, and cases that say if you're 100% and they're working in the labor market, and then suddenly they accidentally take a drink of water when it turns out to be some caustic substance and burns their insides out. And so are you going to say that that person's not entitled to be compensated for their internal organs that have been burned out by an incident that occurred on the job? So I think it's a question of where you place the responsibility. So I don't know if that answers your question, but that's the best I can do right now.
Well, I think it does. And the point is, you're applying the doctrine of direct causation. I don't think employers should get out from underneath. And I've had a number of defense attorneys make this argument. I've seen it done over and over again. And I just say to myself, where's the fairness in that? The employer should be held accountable for any increase in disability or any disability attributable to the industrial injury. And I think that's the way that it should be handled. But what about the converse, Bill? What's the argument that 4662 should not be a statute where the permanent disability should be apportioned or is subject to apportionment?
Yeah, here's my take on this for our case. First of all, it's a divided panel decision. And I think it's important for the audience to understand that panel decisions are not binding precedent before the board. You can cite them for their reasoning. And so here's where I think the reasoning is wrong. I think it's also important to remember that there are other cases that disagree with this conclusion. And 4662 carves out specific significant disabilities, much like police officers who are entitled to presumptions for heart conditions, because the public felt that police officers perform dangerous work and so their heart conditions should be presumed to be industrially related. That cuts to the detriment of many workers. Here, 4662 existed 50 years before the apportionment statutes went into effect. And the legislature carved out as a matter of law a conclusive presumption. It's not a conclusive rebuttable presumption like Dudley dealt with in the Coping case. The legislature said, look, people who are blind, people who can't use their hands, and people who lost their cognitive ability and brain injury, those people are carved out based upon public policy to receive total disability without apportionment. And there are numerous cases that have upheld that principle until this case came along. So I agree with Commissioner Zaleski, who's the chair, that this is not a factual issue. Apportionment, although it is determined factually, as you eloquently pointed out, Richard. But here, as a matter of law, the legislature carved out a special benefit for blind people. And here they've deprived the legislature of its majestic decision to protect blind people. And I think this case is wrong.
Richard, could I add something?
Yeah, sure.
So
Absolutely.
What's interesting is that this issue hasn't been up to the Court of Appeal level yet. And I'm wondering if practitioners are going to take the 4662A issue up before they take the question of whether you can apportion a 4662B total disability case, which is, I think, even a more difficult call than is presented in this particular case.
Well, explain that to me, Dudley, because I might see that the other way. Tell me.
So sure. So if the facts established. So 4660B say if you can, look at the totality of facts that somebody is totally disabled, that is a basis for finding 100%. And so there are other panel cases that say that when the finding of 100% is based under 4662B, that apportionment is precluded in those cases as well. Then you have the Fitzpatrick case coming down, sort of narrowing the applicability of 4662B. But if it's ultimately held that you can't apportion a 4662A 100% case, I would think that the reasoning might follow that you can also not apportion a 4662B total disability case. Does that make sense?
Yeah, in fact, that was a written argument by Mr. Rasp, who now is the presiding judge, I believe in Anaheim. And he said that the renumbering 4 years ago of 4662, he argued was of consequence because it did away with the presumption, the conclusive presumption, according to the fact. And what I suggested was, no, all the cases dealing with 4662B, according to the fact, were always non-presumptive cases because the burden was on the applicant to come forward and establish, according to the fact, the level. I felt that Fitzpatrick really said that this is an authorizing statute, not an originating statute. The originating statute that brings forth the theories upon which you can establish PD is really on a pre-2013 date of injury, 4660, on a post-1113, 4660.1, and that's where you get your different theories of establishing disability. And so I kind of look at this as the conclusive presumption under 4662. The issue is, when does it arise? And I don't think it arises until after it's been established that the disability, whether it be bilateral hands, bilateral eyes, that disability has been established conclusively, or been established as resulting from an industrial event, activity, or exposure resulting in disability, so you have an industrial injury. To the extent that it's non-industrial, I think that there's going to be apportionment. But I mean, I think both of you are correct. This is still, I'm playing the devil's, I'll be playing the role of the defense attorney today. And so that's our position. But these are great issues raised. Anything else, gentlemen?
Well, to carry on with Dudley's comment about Section B, about in accordance with the facts, I don't think any of us have argued that that you can't apply apportionment to B. I think you can't apportion A. So we've never taken the position, at least as far as the cases I've seen, with cost. So the blind person, inability to use your hands, and the brain injuries are conclusive presumptions. B simply allows you to use vocational evidence, other medical evidence, other medical specialties to add up to a total disability.
Okay, I'm going to sit down. Mr. Herreras is up on probably one of the most important cases of the year, and that's the Justice case that answers some of the questions regarding application of Helkitis.
Yeah, to give you a little background, I had the advantage as a member of the amicus committee for the California Applicant Attorneys Association, and for those of you who are lay people in the audience, the amicus committee is a committee within the California Applicant Attorneys Association that appears and argues cases before the courts of appeal and the Supreme Court on behalf of injured workers. So we work with lawyers who are authors of the petition, such as Dudley. When he argued the Coping case, we appeared as amicus curiae, as a friend of the court. So I've had the advantage in this case, in the Justice case, that I appeared and it was a signature on the amicus brief filed by the California Applicant Attorneys Association. We prepare the amicus briefs and we argue in the Court of Appeal. The Justice case occurred during the pandemic, so we didn't look the justices in the eye when we argued this case. We did it by telephone. But in order to understand the Justice case, which is a Sixth Appellate District. It rose out of in Santa Clara County, San Jose, with the Hikita case. The Hikita case, we were also involved in it as amicus curiae. And I want to explain that case first before I explain the Justice case, because it deals with apportioning disability caused by the medical treatment, the industrial medical treatment. So let's talk about Hikita. Hikita was decided in the Second Appellate District versus Justice, which is in the Sixth Appellate District. And in Hikita, the applicant suffered carpal tunnel syndrome. And as a result of the medical treatment, she acquired complex regional pain syndrome. And as you know, that's a very serious, disabling, controversial condition. And the internist in the case said, I think this woman can't work, but I think the 10% is non-industrial, and she's totally disabled, and that the cause of the disability was the ineffective or unfortunate consequences of the industrial medical treatment that was provided the applicant. So in Hikita, the evidence clearly demonstrated that the industrial medical treatment worsened the applicant's condition. And it was the cause of the 100% disability. The Court of Appeal, Second Appellate District in Hikita, held that we've never apportioned, as you all know, medical treatment. The Granado case held that you do not apportion medical treatment, and since the employer has the responsibility for providing the medical treatment, they should be responsible for the consequences of the medical condition. And therefore, we hold that there's nothing in the apportionment statutes that have undermined that basic principle that the employer is responsible for the consequences of the medical treatment provided for by the employer. So Hikita is sitting out there, Second Appellate District, published a Court of Appeal opinion, and along comes Ms. Justice, who, interesting, was ironically, a former claims examiner. And she injured her left knee on the job. And as a secondary consequence, she then injured her right knee. And eventually required 2 total knee replacements. And the AME in the case, and I think the defendants, I thought, did a pretty good job on developing the evidence regarding apportionment. And this is what they produced, and I should read this to you. The underlying factual information that supported the apportionment. The AME said the MRI reveals significant pre-existing degeneration, all of which predated the fall at work. An old tear and anterior cruciate ligament marked loss of articulate cartilage in the medical compartment, moderate loss of articulate cartilage in the lateral compartment, and moderate loss of patellar joint. There was also a scar tissue on both knees, indicating that Justice had undergone a significant open procedure at some point in the past. So there's your factual information that Richard talked about. And then Dr. Anderson, the AME, went on to say, he testified that there was significant pre-injury degenerative condition to both knees. And in response to the question asked by the defense attorney, that the injury itself would not have required, the injury would only cause the meniscus tear. And as a result of the meniscus tear, that would not have required the total knee replacements. And the AME went on to say that it was probable that before the injury, the applicant suffered 50% bilateral knee disabilities from non-industrial conditions. So the trial judge, reviewing this case, said, you know, if I had not seen Hikita, I would have apportioned this case, because that's powerful evidence of a pre-existing condition. But he said, "Who am I? I'm a lowly workers' compensation judge." And he actually put that in his opinion. And I have to follow the Court of Appeal, I can't explain why they did what they did, but I'm not going to portion this case, because the knee conditions, according to the AMA guides, produce the disability. In other words, the knee replacements themselves, the metal apparatus in the knees, produce the 40% standard. Not the degenerative changes, not the pre-existing tears, not the previous surgeries, but the mechanical implementation of the knee replacements. So I'm going to follow Hikita. I'm going to give her 48%. And it went to the board, and the board said, well, yeah, listen, Hikita, it's the cause of the disability was the medical treatment, the implementation of the steel processes in the knees, and there's no apportionment because that was a result of the medical treatment. Went to the Court of Appeal and said, not so. And this is reason why. Well, first of all, of course, the sky is falling, because 899 said that employers are losing money in workers' compensation and it's too expensive. And so we don't want to compensate these injured workers for conditions that are not caused by their work. So we're going to take another look at this. And then they turned to the City of Petaluma case, the Lynn case. It's another case we argued in the Court of Appeal as amicus, lost. It involved a police officer who suffered a eye condition and eventually ended up with a blind eye, but he had a pre-existing condition that was pathologically contributed to the disability, and the court said in Lynn that we're going to follow the legislative mandate to impose apportionment, and we think that a pre-existing non-disabling a pathological condition is subject to apportionment. And then what's also peculiar about this case is that Miss Justice medical condition improved. The knee replacements made her more mobile, less pain, was able to ambulate better. So the surgery was helpful. Whereas in Hikita, the medical treatment was damaging. So the court concluded that there's an exception to Hikita, and that the apportionment provisions of the law should be applied consistent with curing the economic crisis, and the opinion of the AME, which is compelling, justified apportionment because, as contrasted to Hikita, there was a change in condition and an improvement of the condition. So our conclusion is that this is an exception to the Hikita rule. It did not overrule Hikita. We didn't agree with this case because, again, in the Hikita case, there was a case called Steinkamp. And Steinkamp held that a knee replacement removed the degenerative changes in the knee, and the disability is based upon the apparatus in the knee, and there's no apportionment. That case was cited as a footnote in Hikita. So we argued that the Steinkamp principle and the cause of the disability was the steel apparatus in the knee, and there should have been no apportionment. But that's a justice case.
Do you want me to go first, Dudley, or do you want to?
Oh, no, you go ahead, Rich. That's fine.
Okay. Here's my see. I don't see the justice as an exception, and I agree with you that Hikita has not been overruled. It's still a valid legal principle by way of application. but I see it merely as explaining to us when Halkida applies. And I see Halkida and justice as really application of the doctrine of direct causation. I think an employer is still liable for virtually 100% of the disability resulting from medical care. Where that disability is resulting from a new condition, and they use this language in the case, a new condition, not previously. In other words, it arises out of the medical treatment. At that point in time, I think the entirety of the liability is going to be with the employer. There's no, and that is the classic Halkida. Halkida, I thought, turned on the fact that we had a different diagnosis, not previously involved or related. And it was bilateral carpal tunnel that after surgery developed complex regional pain syndrome. And that diagnosis was new. The disability associated with that, therefore, was new. And he had a direct causation from the medical care, because disability resulting solely from medical care is non-apportionable. I agree with that, and I think that's what Halkida stands for. But what I don't believe Halkida stands for is that medical treatment sanitizes the argument of for apportionment. And what I mean by that is, and I always thought when I discussed in 2008, the CAW invited me to speak on a panel on apportionment. And what I said about Steinkamp that nobody agreed with was that it was a how and why case. If the doctor had in Steinkamp said that it was the chondromalacia that became symptomatic that led to the need for a total knee in conjunction with the industrial injury, and but for the non-industrial component and the industrial component, and we've had subsequent cases that have suggested this, if the doctor had connected those dots and said this is the basis for the apportionment, and we wouldn't have needed the total knee replacement surgery but for a combination of the non-industrial and industrial components. That's not what the doctor did in Steinkamp. He just jumped to the end game and said, I'm going to apportion. He never explained it. So I thought it was a how and why case. But I do agree that Halkida survives. Where you have, and I think this is the classic, where you have a new condition that results from industrial injury, there is no basis for apportionment. And I think that's where the defendants have to be careful and be aware of that.
My 2 cents. I have to agree with Bill's analysis. And the logic here is what really challenges me. If you look at the applicant's condition, specifically their permanent disability when they're permanent and stationary, I don't know how this result can be achieved. In 2005, when the AMA guides were adopted, the system decided to rate employees' permanent disability by various methodologies, including the total knee replacement. So if that's the basis for the impairment, i.e. the permanent disability, I don't know how, if that procedure, if that total knee replacement removes all the degenerative changes, removes all of the apportionable factors, we can go back in time and attempt to apportion it. That's where I'm just really logically troubled by this decision in justice.
Well,
go ahead, Rick.
I think you make a good point, and that turns on whether or not a doctor can address the apportionment where his opinion is going to constitute substantial evidence. I think it's a difficult, but here we had a doctor that looked at the pre-existing pathology, the pre-existing injury, the scarring, and said, listen, based on reasonable medical probability, this is how I would apportion it. And if a doctor is able to do that, I think he can do that. But I think the extreme is also incorrect, which is you had some medical treatment, so it sanitizes all apportionment.
Well, so that's an interesting term, sanitizes. I don't think we're apportioning the medical procedure. We're not apportioning the total knee replacement. We're apportioning applicants' permanent disability when they're permanent and stationary. That's the point in time that we're looking at the permanent disability and the direct causes of that permanent disability. And if the permanent disability is solely based on the total knee replacement, then who cares if this person had chondromalacia prior to their industrial injury? It's not a factor in the permanent disability. So I just look at it from a logical standpoint. I can't reconcile justice personally.
If you look at the AMA guides, 17.33, there's no diagnostic part of that AMA to follow up with what Dudley's saying. Again, the disability is the metal implanted in this person's knee that justifies the 30%, not the degenerative changes, not the pre-existing condition, but it's the apparatus itself that is the cause of the disability, which is the medical treatment. And that's the argument. I don't think the Court of Appeal understood, and particularly during oral argument, when you're trying to explain to this to a Court of Appeal by telephone, we were severely hampered in terms of explaining that the disability was a result of the medical treatment.
Yeah, I would agree that both you and Dudley, your analysis is much more complex than mine. Mine's fairly simplistic, which is he had pre-existing pathology. It was evidenced by scarring, a prior injury, and that in conjunction with the industrial injury resulted in the total knee. And that total knee, which you're rating, is now the result of both. And see how simple that is? And so probably the judges could understand that the simplicity of that argument and followed it, you know?
Mine's even simpler, Richard. What was the cause of the permanent disability, and is there any non-industrial aspect to that?
Well, I think there is, because that's what led to
fewer words.
But isn't that what led
yeah,
to
you have to look. But your analysis has to go back to the time of the surgery and what led to the cause of the need for the total knee replacement. Mine just looks at the PNS status. What's the cause of that permanent disability, period?
So your position is that, to use my word, it hasn't appeared in any decisions yet that the surgery sanitizes, wipes out any basis for apportionment to pre-existing that led to that surgery. That's the argument,
to the
isn't
extent it? I guess so. To the extent it no longer exists at the time we're actually applying apportionment, then yeah, I would agree with that.
Yeah.
I agree. I agree with that as well. That was
now that we're having
Go ahead.
Well, I was going to say, now that we're having an agree fest, I also agree that the employers were losing money was the basis for apportionment is kind of, I heard the sarcasm there, and I didn't fall on deaf ears.
I think we should take a vote on this.
Well, I think it's, again, ironic. There was a claims examiner who unfortunately had her disability apportioned.
Isn't that so? Okay. And I did cite one panel decision in the box, this is on page 3 of your materials, that says that to the extent that the holding is in conflict, there is a conflict between Justice and Alkita, the WCAB is free to choose between the conflicting application. So, okay.
Yeah, the test is it worse or is it better? That's the test.
Expand on that. What do you mean by that?
Well, if the medical treatment improved the condition, then Nikita doesn't apply. If the medical condition worsens it and is the cause of the disability, then there's no apportionment.
That would be a bright line, simple bright line rule. I think it turns on whether or not the resulting condition is a new condition, and you have no basis for apportionment under that scenario. But anyway, we'll see. This is not the end of this is not the last act, that's for sure, on this issue. Okay, let's move on to employment AOE COE and the CPS security case. And I think Dudley's going to take that case.
Sure. Let me just briefly touch on the it looks like on SB 1159, and it's very apropos to the pandemic and what's going on. That is, as most of the viewers probably know, is the presumption that an illness or death resulting from COVID-19 is presumptively compensable, where within 14 days or days of a day that the employee performed labor or service at the employee's place of employment at the employer's direction. And in the materials, you'll see Rich's comment in the box, and I totally agree with that comment, that if you've got an employee that is at all public facing or is working around coworkers with COVID, independent of this presumption, I think you have a compensable claim there. But just to point out, Senate Bill 1159. As far as AOE COE is concerned, we also have on the next page, Leggett versus CPS Security. Leggett is a very interesting case. It deals with a fellow who worked as a night security guard. He worked up to a certain point in time and then filed a specific date of injury effective his last day of work. The allegation of injury related to mosquitoes that he was exposed to as a night security guard, ultimately leading up to the diagnosis of West Nile virus. And the judge sort of looked at it and said, well, there's really no evidence of a mosquito bite on his last date of work, so there's really not substantial evidence to support a specific date of injury. We're not going to find an injury here. And the commissioners looked at it and said, not so fast, that you could have a specific injury causing an occupational illness and still fall under Labor Code Section 5412. So Labor Code Section 5412 is critically important, and understanding it is critically important if we're looking at cumulative traumas or occupational illnesses. And here let me slow down a little bit. Labor Code Section 5412 says that the date of injury, not the period of employment, not the period of injurious exposure, but the date of injury is the date when disability and the knowledge that the disability is work-related, when those two factors coincide, you have a date. And here the commissioners basically say, well, that date can be pled as a specific date, but we're still going to look at it in terms of 5412. And here there was no dispute that this fellow was exposed to mosquitoes. So you had a viable mechanism of injury, and that led to his diagnosis of West Nile virus. And so they reversed the judge and found it industrial. The case itself reminds me a lot of that Rosas case, where in Rosas you had a sewage worker who developed hepatitis. And the Court of Appeal in Rosas said, well, the applicant's burden isn't scientific certainty, it's something more than a mere possibility. And that's also consistent with the South Coast framing case that Rich mentioned earlier. So they're really looking at, whether there's a feasible mechanism of injury here. I think if you were to really analyze Leggett carefully, you would realize that the date of injury as pled was not pled correctly, and the injury as found by the WCAB was not the actual date of injury. The record doesn't set out what when the applicant first suffered disability. The record doesn't set forth when he obtained the knowledge that disability was work-related. So I question whether the date that was actually found in this case is even correct. But it is a Labor Code Section 5412 case. And, during my time as a judge, if there was an issue that came up time and again, and that was the proper pleading of cumulative injuries, especially when you have a latent disease such as cancer, those claims can be very difficult to adjudicate if they're not initially pled correctly. I had a hearing loss case where it was originally pled as a 1985 case where the applicant was exposed to this loud explosion. Then he worked through 2000. The case went to MSC. The claim was amended to a cumulative trauma for employment through 2000. On the date of the MSC, it was then amended again to reflect date of knowledge of when he met with his attorney. And then at trial, the employee testified that he had no knowledge his hearing could be work-related until he saw the QME a year after the time that he saw the lawyer. And as the judge, I said, enough already. I gave him a take nothing on the 1985 injury. It was appealed, and the commissioners basically reversed me and said, hey, you need to do the exploration as to determine what the correct date of injury, in fact, should be. So we had further proceedings on that case. I only point that out as it can be a very challenging issue to determine the correct date of injury. And whichever side, whether it's the defense or applicant, if you really put some thought into that issue initially in the pleading of the case, it can really serve you well as the case goes through the process.
I think this case also illustrates some common sense and appreciation for workplace workplace exposure. I mean, does it just make sense to you that that a person that works around mosquitoes and picks up West Nile virus, it's work related? And does it really make any difference whether it happened on day 1 or day 15? It just the same thing with the Rosa case that you talked about. That was Barry Williams' case. I don't know if you remember Barry.
I sure do.
Was very active in our association. Fine appellate lawyer. We worked with him on the amicus case. And then the other part of this case is that the pleadings in workers' compensation are informal. They're not formalized, rigid boxes that you have to find specific dates. The courts have repeatedly said, as in your case, Dudley, you base the decision based upon the most likely facts. Is it a specific injury or is it a cumulative injury? And so the formalities of pleading are irrelevant in workers' compensation as long as you arrive at the most reasonable, rational explanation of how the injury arose.
So yeah, I agree that pleadings are informal. I have found, Bill, that if it is pled correctly, though, for example, on a cancer case, and let's say the applicant last works in 2012 and is diagnosed in 2019 with cancer, a lot of practitioners out there will file that as a cumulative trauma through 2012. And that immediately gives the defense reason to question statute of limitations, timeliness of claim. Where if the applicant's counsel really says, well, wait a second, the exposure was back then, but under 5412, the date is a specific date in 2019 as to, when, let's say he spoke with his attorney in 2019 and realized, hey, there's a presumption I can file this. It really sort of puts the onus back on the defendant to say, okay, prove that that's not when the knowledge was obtained. I don't know. I think it makes for a much cleaner case when it's really pled properly to begin with.
Yeah, date of knowledge versus date of exposure can be two different things.
Correct. Yeah. No, but I agree with you. I think this case reminded me a lot of that Rose's case, and there is just a common sense element to it. Like this is, he had the exposures at work, and he shouldn't be denied of benefits because he technically listed it as the last date of his work.
What difference does it make whether it happened on September 22nd or September 23rd?
Right. I agree.
If I could just jump in, a couple of cautionary comments. First of all, when it comes to the statute of limitations, there's not a defense that's more asserted by the defendant and less often sustained. Generally, statute of limitations, I look at it as a negotiating tool to resolve a case. Second, there is some exceptions in the case law, and the exceptions seem to be where the applicant is represented. These are the facts. The applicant's represented, and the medical doctor says specifically there's an industrial CT or specific injury, and with that knowledge, there's no timely filing of that. One other situation that everyone should be aware of, every applicant attorney should be aware of, is that if you have those two facts, and if you file for an MSC, and if you try to amend after that MSC or at the time of MSC, where there's been, and listen to these elements, where there's been a prior decision in the matter, and I had this arise. What happened in my case was I had objected to the MSC, the DOR that was filed, timely objected because I wanted a deposition. Gilbert Lang was the QME, and towards the end, he passed on. He was having some, let's just say that we needed to develop the record more fully. I timely objected, and the MSC judge decided, no, we're going to set this over my objection. Then, at the MSC, I requested an order closing discovery. I then filed a petition for removal. Of course, they can go forward to trial. The judge has discretion there. The judge decided to wait for the petition for removal to come back. It was not sustained, but now I had an order. I had an order that where a judge had ruled in the matter based on the 5-pager. The 5-pager only had a specific when the QME who had passed on had indicated it was only a cumulative trauma injury. Counsel for applicants sought to amend at trial. I objected. I did a trial brief, and there is a 3rd District Court of Appeal decision that is controlling that says at that point, amendment cannot go forward. And at that point, that date of injury was arguably barred by the statute of limitations. Now, what I did in that situation was I gave a copy of my trial brief to the judge, and I gave a copy to the applicant's counsel. I did not file it with the board at that point in time because I wanted everybody to understand what was going on, and it wasn't my desire. It was my desire to settle the case, not say I gotcha. And counsel for applicant and I, to his credit, he said to the judge, I'm in a situation where I might have a conflict of interest if I settle the case because of my past handling of the decision. And I had to take my hat off to him. I thought that was very impressive for an applicant attorney in open court to admit that. But what did we do? Did I hold him underwater? And no, I didn't. What I did was I came up with what was a fair and equitable resolution, and he and I settled the case. And probably that's instructive on how attorneys should behave between one another. Both him forcing it to hearing when we had a problem in the record, but also once I gained the upper hand, being willing to resolve the case. And I think that was a good outcome. But be aware of that as applicant attorneys, I believe, I agree that you can amend right up, but at some point you can no longer amend. And think about those elements. Number one, it has to be a date of injury that there's medical evidence. The applicant has to be represented. And in my case, we had an order based on a 5-pager, and that pretty much solidified, and we were beyond the 1-year statute. So that pretty much solidified it and allowed me to negotiate a resolution that was appropriate. I did not, I wasn't aggressive in that because I did what I thought was right and what was fair under the circumstances. But
yeah, I would say that just one final point from my perspective is that there's no question that there are liberal pleadings in workers' compensation cases. However, as the trier of fact in that case I mentioned, at some point the defendant has to know what injury they're contending with. And when we got to the Fourth Amendment, I think he filed a brief a week after our trial asking for a Fourth Amendment of the date of injury. Again, as the judge, I felt there were due process issues where, this has just been an impossibility from, really the MSA forward for the defendant to know what case they're preparing against. But we see these issues, the court sees a lot of these dates of injury issues get litigated.
Okay, I'm gonna shotgun page 5. We're gonna get through these fairly quickly. We have the Kong case. This is a special missions exception to the going and coming rule. Here the applicant was working on a weekend preparing something, and on his way home on a Saturday he was injured. Only minutes after, very good facts, only minutes after calling his supervisor. So they said, they held that this was a special mission exception to the bar provided by the going and coming rule. The next case, the Liu case, is a zone of danger case. And what's critical to establish zone of danger as a special risk exception to the going and coming rule is the fact that the applicant at the time of the injury has to be put at a greater risk of whatever the injury is than the general public. The Brawley case, the reason and one thing I do in my book is I put entries in there that really are succinct descriptions or definitions of injury. And this is a cumulative trauma injury, and it requires the concurrence of injurious industrial event, activity, or exposure, resulting disability, which can be TD or PD, and knowledge or reason to know that there's a cause and effect relationship between the injurious industrial event, activity, or exposure and the disability. The next case is interesting. This came out of the Reading Board, this Grund case. And this is an example of why sometimes the employer wants the applicant within the course and scope of employment to apply the exclusive remedy rule under workers' compensation. What happened was, this is a rural community, and I think this was handled by Stephen Riley at the Work Comp Center up in Reading. But what happened here was the applicant was asked to assist law enforcement. And the issue was whether or not that request fell within 3366 and therefore whether or not the injury was within the course and scope. There were some really great facts dealing with civil liability, and the issue was whether or not it would be barred. The facts included the fact that when they asked the private citizen to assist, that they didn't tell them that there was the potential for criminal activity going on. They suggested that it was a call related to the inclement weather. Let's go down to the LA Unified School District at the bottom. You know, this really flew in the face of my, I didn't like this case, even though the defendant won. And I'm just going to read my summary here. The issue was whether or not it was claimed by, whether or not the injury was barred by Labor Code Section 3600A, the initial aggressor prohibition. In other words, whoever starts the fight can't claim later that he got injured on the job. And the evidence here established that the student yelling and inadvertently spat on the teacher, the applicant, the teacher applicant, prompted the teacher to slap the student, resulting in the student punching the teacher and causing the injury. The evidence established that the spitting was inadvertent and related to the verbal altercation of the teacher. It was the teacher who first initiated the physical altercation. There was no evidence that the applicant, the teacher, was in reasonable fear of physical attack before striking the student. I get the application. I think it's interesting, but boy, if I were a teacher, I'm not sure I would slap a student after this case, especially where the student was yelling and spitting on me. But I can't imagine. This is not where you have two employees getting into a fist fight. This is really the teacher trying to maintain control in the classroom. That's the way I saw it. I don't know that if I were a teacher I would strike anyone, but this is. It seems to me that if he was injured, he should be allowed to pursue a workers' compensation claim. But they held that he could not. The next area that we want to discuss a little bit about is compromise and releases. And I have a case here, and you can read that. But what I want to do is throw it out to the panel. And here's the hypothetical that I really would like to hear from Judge Phoenix as well as Mr. Herreras on. And this is an issue that is reoccurring in my office. This is a situation where you have a specific claim of injury to the low back after 20 years employment as a warehouseman. The only claim of injury that's pled is a specific. There's no issues on apportionment. It's valuation of the case only. And whether it's a CT or a specific, it's only going to reduce the value because the second date of injury gives rise potentially to the Benson application, which will reduce the PD. And here's my question. Where you have a specific claim of injury that you're settling by way of compromise and release, should a WCJ approve a unassigned, unpled, cumulative trauma injury through the last date of employment for the purpose of that part of body claimed to have been injured by the specific? I'll throw that out.
Okay. Well, I can speak to this perhaps maybe as a former judge. There's a couple of issues with that. One is there's no case number on the cumulative trauma yet. So that would have to be set up by a secretary or a clerk. The second issue from the judge's perspective is that there's probably no medical evidence addressing the cumulative injury. And so without there being any medical evidence, it becomes really difficult to evaluate adequacy. And so as the judge, probably the easiest approach would be to disapprove that. Now, if I were the judge and Rich, you came in and said, look, there's a bigger picture here. We're really trying to bring some, closure to this workers' comp case, and there's really not a cumulative trauma. We're kind of including that for purposes of wrapping everything up. I mean, I would definitely listen carefully, but those are some of the challenges from the judge's standpoint.
Well, could I ask this question?
I think to follow up with what Dudley's talking about is it depends upon the type of work the worker did and the type of injury involved and the length of time that employee worked for the employer. And so if you have chiropractic records of pre-existing complaints of pain, with a back injury and you've got a specific claim, I think you have to provide some rational basis for explaining why you need an unassigned cumulative trauma claim.
And that's what, let me give you two scenarios here. First of all, I agree. I believe the rule of law should be this, simply stated. The judge's role in approving a settlement starts and ends with adequacy. Certainly you have to make sure the pleadings and all that is correct, but I think it starts and ends with adequacy, whether or not the amount, the consideration provided is adequate. And certainly they have to have an evidentiary record sufficient to do that. In my scenario, though, we're dealing with the same part of body. There's not going to be any increase in PD. There's no additional issues regarding medical treatment, the scope of medical treatment. So the judge should be able to evaluate that without further evidence. And the only outcome of an additional date of injury on valuation would be arguably to reduce it through application of Benson. So I think that the judge should be allowed to review that and approve it.
Well,
I can see
if I could just to give maybe a different perspective, that I understand what you're saying, but as far as what Bill was saying, let's say the applicant was in a very arduous type of occupation, there may be a valuable or a potentially valuable cumulative trauma there. And Benson's not the only consideration. Is there potential TD related to that cumulative trauma? Is there potential permanent disability related to that cumulative trauma? That's what the judge is going to be looking at. As a judge, what I saw a lot of is where in paragraph 9 of the compromise release, the attorneys would write in that this settlement is intended to include all injuries occurring, up to the applicant's last date of work, whether pled or not pled. And I'd always ask counsel, I'd specifically ask defense counsel, like, if there's a cumulative trauma here, why don't you file or, create a case for that? Because until there is a case and a case number assigned, you're really not closing down that cumulative injury.
And understand the unassigned CT, we always assign case numbers to it. We come in, we have an unassigned on it, and we request that it be assigned. But what I'm suggesting is that perhaps the rule of law should be where there's prima facie evidence to establish the presence of a cumulative trauma. And that evidence, I think Bill alluded to it, it's going to be, what's the physical component? How long was the employment? Is there actually the basis for a CT, whether or not it was developed in the medical record or not? What's the impact of an additional CT on the valuation? Do I have sufficient evidence as the WCJ to determine the adequacy of the settlement? And I think generally that should apply. But so I think the rule of law should be prima facie evidence of cumulative trauma allows a party to submit for determination on adequacy and approval of a compromise and release. But let me twist this fact pattern one more, because I had the other case. I have another case right now, and I've taken the first example. It went up to the recon unit, and it's coming back down for hearing with direction in a few weeks. But here's another case that I have right now. We have somebody who, the file was pulled from another firm. And one of the things that I do as a defense attorney when a file is pulled is I don't necessarily give the client what they think they want. And often what they want is for me to point the finger, and I just don't engage in that. I'm always a straight shooter on my evaluation. In fact, I often send my initial file review to the prior attorney. In this case, it was pulled, and they had a CNR, and it included one date of injury. Then the applicant came back and filed a second date of injury a week later, specific, involving the same part of body. This is a Southern California firm that did this for the applicant. I turned around and I was pragmatic. I said, listen, it's going to cost us, between medical, legal, and my time, it's going to cost us $5,000 or $10,000. Why don't we try to just wrap this up for $5,000? And in doing that, I didn't realize what I was doing. I was really feeding the animal. We got that approved, and within 30 days, we got another claim of injury. And this is the third date of injury from this applicant, and he's I won't tell you what he does for a living, but they're all unwitnessed. And what he's doing is he's picking successive dates of injury, realizing that potentially with each one there is a willingness on our part to pay money to get rid of it. Now, I'd say two things. The applicant attorney that engage in that type of a behavior, I think is, I can see an improper. don't understand why an applicant attorney would engage in that. But in this case, what we're going to do is, certainly the analysis is that the prior settlement, prior level of disability is going to wipe out via apportionment any disability, but our potential liability, if that date of injury is established, is going to be the unapportionable benefits. And now certainly under the Foster rule, where you can't stack PD due to successive injuries where the concurrence causes the temporary disability is going to apply, but we're still going to be on the hook for the medical treatment, which is not apportionable. So how do we as defendants handle that? Do we just stip everything? Or do we, I'll tell you what I do, is I try to CNR everything, and then I explain to the client the potential with settlements now where the judges won't approve other dates of injury unless they've been worked up. In this case, it would have been nice to have been able to put in there any and all dates of injury arising out of the subject employment, but that, no judge will approve that. Do you see the dilemma from the defense side?
No, I totally do. I think, that you want closure. You want to get a bang for your buck when you settle a case by way of compromise and release. Just from the judge's standpoint, there's an adequacy issue. What's the cumulative worth? And, if applicants represented by counsel, it makes it a lot easier. I would, if I were a judge, I'd want to talk to the applicant's attorney, whether it's been, considered, discussed with the client, that sort of thing. There's a balance as a judge as to, letting work move forward, letting cases get resolved and frustrating that process by asking for evidence to support the cumulative injury, for asking that case numbers be formally set up. There's always that balance as far as the job is concerned. I do understand the concern. And I know when I started as a judge, I wouldn't approve certain language in a compromise with release, relating to, the period of employment. And I think I became a little more flexible about that as my tenure proceeded. But there's an adequacy issue. That's kind of my perspective.
Actually, I'm appalled by that conduct, Richard. I think it besmirches our reputation as lawyers and litigants to engage in that kind of piecemeal abuse, and I think it's close to vexatious litigation.
I agree. I don't have time for it personally. I don't know they have the time to file those repeated claims.
Well, this is that we just got the third claim, and I had a meeting just this past week with the adjuster and the supervisor, and I had to explain to them that the prior attorney didn't do anything wrong. Certainly, my analysis was concrete with the second date of injury, and the judges won't approve any and all. And so we're forced to, on this, I'll tell you what my analysis was. We've got to make the applicant attorney pay for it. That means that we can't feed that type of behavior. We've got to go after them and litigate this and show them that they're not going to benefit from this. And it's a small case, so it's difficult. Okay, we're not moving, gentlemen, as fast as we should. But I'm still going to take a break. It's 10:30. We're going to take a 15-minute break and for a few words from our sponsors. And then we'll return starting with on page 6 with the cases involving COVID. Okay.